Welcome to Sakshi TV's special immigration show with attorney Bhanu Babu Illindra from BPI Law Group. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with attorney Ms. Prashanti Reddy, on Thursday at 5:30 p.m. EST with attorney Chand Parvatnini, and on Friday at 6 p.m. EST with attorney Bhanu Illindra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice. Use of content is for general informational purposes only. Sakshi TV or its agents in the USA or our guests on this show are not responsible for use of information as a legal advice. If you need specific legal advice, please contact the attorney directly. We will also be taking any general immigration questions along with today's topic. Hello, Bhanu Garu. Welcome to the show. How are you doing?
I'm doing fine. Thank you. Thank you for calling me back to the show again today.
Of course, we're privileged to host you, sir. So before we get into the show, could you please give us a little information about how our viewers can reach you?
Sure. Viewers can reach me by email, by telephone, either way basically, or even by text message also to my cell phone. That's the best way to reach me. All these 3 ways they can reach me. Mainly, I would like to introduce about myself and my firm. Namaste Andy, all Sakshi viewers. My name is Bhanu Illindra. I'm an immigration attorney in the US. I've been practicing immigration law for more than 18 years in the US. And I started my own law firm in the US in 2008, located in Herndon, Virginia. And we are staffed more than 25 employees in the country and more than 20 employees in India. So we have more than 45 employees, overall total staff equipped in our law firm. And we represent in all types of immigration matters, Andy, is inbound and outbound, mainly inbound. That is, the people who are migrating to the US, we represent those matters. There are mainly different types of immigration cases we have, like employment-based immigration, family-based immigration, EB-5 investor visas, employer compliances, employee compliances, I-9 issues, whatnot, naturalization cases, whatnot, every type of immigration matters we actually represent from a firm. Our full name is BBI Law Group PC, and our website is www.bbilawgroup.com. My contact details are, my office number is 703-496-7722. My mobile number is 319-400-0053. My email ID is bhanu@bbilawgroup.com. If you have any questions, do you need any help with your immigration matters, kindly feel free to reach our office. We are very happy to assist you all. Once again, thank you, Torani and the Sakshi TV, for giving this opportunity for us.
We're more privileged, sir. But before we get to the topic, do you have any latest immigration updates that you'd like to discuss?
Yeah, I mean, not much happening in recent times, but I would like to discuss a couple of issues which are ongoing issues for the audience, basically. One is their green card processing, especially an employment-based green card processing with the priority dates, availability, visa bulletin. Those issues I'm going to discuss. And second one is H-1B cap, okay, for fiscal year 2023. Now, we are in the last phase of the H-1B cap eligibility to file H-1Bs for fiscal year 2023. That is with the start date of October 1, 2023. And the lottery has been done in March. Now we have 90 days time to file H-1B petitions. And in those 90 days, we are left with only 27 days more, last 27 days, because you have to file the petition from April 1 to June 30th. Okay, and now we are already on June 3rd, so we have 27 days more. We are urging all the employers and employers who are interested in filing their H-1B petitions, make sure that they start working on them. Do not delay any more further and try to file them as timely as possible so that you won't lose the opportunity to seek an H-1B visa during this fiscal year, especially if you got selected in the lottery. You know, we are advising our clients is try to submit all the cases by June 25th to June 26th so that we won't miss any cases reaching the USAs by June 30th, even if there is a delay with the courier services like FedEx or USPS or UPS or anybody like that. Because sometimes these courier services can miss the package or delay the package. Under those circumstances, we won't miss the opportunity. So we urge you all to make sure that you all file these cases timely, prepare well, make sure that you use the lawyers, competent lawyers to prepare your cases like a firm. There are hundreds of lawyers are there, and we are one of them, and we are very confident that we do a very competent job in the market. And at the same time, we advise whoever the lawyer you are working, make sure that those cases are properly prepared, and timely filed prior to June 30, 2022, so that you can take advantage of getting selected in the lottery. And a lot of people are asking me about this also, that whether is there going to be a second lottery because they did not get selected in the first lottery. We do not know that yet. We have to see how many cases will be filed by June 30, 2022. And if they did not receive the number of petitions, that is basically 65,000 and 20,000 from ASOS cap, that number of cases, then probably USS will conduct a second lottery again in July. And so it's very difficult to say right now because of the way the things are going in the country, how many cases will be filed, how many cases will not be filed for this cap. And next, that's why my request to all of you is that make sure that the process is started as early as possible so that cases can be filed timely. Second issue, as I said, which I discussed in the beginning, that is about the visa bulletins for the employment-based category. We all know, we discussed this in past shows also, and now also, is that the visa bulletin for the month of June 2022 for the EB2 category, especially for the Indian nationals, moved significantly forward. They moved 1 year from September 2013 to September 2014, final action dates. So if any one of you have a valid EB2 I-140 petition with the priority dates on or before September 2014, and if your employer is willing for you to seek adjustment of status based upon that EB2 I-140 petition, and if you already filed your adjustment of status application, kindly ensure you seek interfiling, request interfiling with the USCIS, so that you can take advantage of the visa numbers available in EB2 category as advised by the USCIS. We are running out of time because this fiscal year ends in September 30, 2022. Again, for the next fiscal year, we do not know how many excessive number of visas available in the employment-based category besides 140,000 visas, because we do not know how many family-based visas have been issued abroad. I personally do not know. I don't have the data with me. So as of now, personally, I'm not aware of how many family-based immigrant visas have been issued abroad at various consulates, so that we can get those remaining unused visas will be to the employment-based category for the next year also. So try to take advantage of it. If you have a existing I-140 in EB2 category with the priority date on or before September 2014, or a pending EB2 I-140 on or before September 2014, please take advantage of taking the advantage of interfiling process, which is actually legally it's called transfer of underlying basis, but in general lingo we call it as a interfiling. Please take advantage of that. That's very, very important. And US is also recommending you all to take advantage of that. And we are seeing now a little bit movement from the people taking advantage of that, trying to making the interfile requests and everything. But somehow there was an apprehension in the past, but now we are basically letting all know that don't have any apprehensions. The policy has been clearly detailed by the USCIS, how it will be implemented, how it will be processed and everything. Please go through it, use it, and take advantage of that. And in our office, when we did the interfilings for the month of December and January, some of them cases have been already approved. They got the green cards. So we are advising people to follow that, to do that for a long time ago. And that's what we are advising you again, even now also, to take advantage of that so that you all can get your green cards in this fiscal year and able to pursue or plan your career and the life and the future in the United States accordingly.
Right. So, since Bhanu, thank you so much for all the information you've given us. But before moving on to our FAQs and the other questions that we have, since H1B has just started getting some movement and it's going forward, would you want to probably talk about an approach for other kind of work visas apart from H1B?
Yes, definitely, Turni Garu. And Other type of work visas generally available for the people to come to US are L1 visas, O1 visas, P1 visas, P visas, OP visas. And if you're coming in a diplomatic category or in the government official categories, you have other diplomatic or government official category visas, which is A2, A visa and other visas, which is very, very rare. We don't use that many because that is usually used for the officials and the diplomats. You know, so majorly for the people, individuals who can come to US to work are H visa, L visa, O visa, and the P visa. These are the four visas that are available for the people to come into this country. And also there is one more visa which is called J visa, which is a training visa, which is an exchange visitor visa. Okay, that means usually J visa is used for the training programs like if you want to do residency as a medical student to become a doctor in the US, you can use the J1 visa program. That's where the J1 visa programs is used. And for the training programs, like if you're coming into this country to get some kind of a training in hotel management or in restaurants or anything like that, running restaurants or anything like that, J1 training programs can be used. So those are the typical 5 types of visas which are used. And L visa is mainly meant for the intra-company transfers. That means if there is a company in India have their branch or affiliate or a parent or associated company or related company in the US, and if an employee is working in that Indian company at least for 1 year in the past 3 years, that employee can be actually transferred to the US company, to the affiliate company, to subsidiary or a parent or a related company as an intra-company transfer. For that, you can use L visa. And in L visa also there are 2 types of visas for working. One is L1 visa, which is meant for the executive or a manager, intra-company transfer executive or a manager. If somebody coming in executive role or a managerial role, they can use L1A. And if somebody is coming as a highly specialized knowledge individual or a skilled individual, then they can come on L1B visa, and their dependents can get an L2 visa, and dependents or others to work in this country pursuant to their L2 visa in this country also. And other visa, as I said, is O visa. O visa is meant for the extraordinary ability individuals. That means if somebody is very well qualified in their field of endeavor, had a very high achievements, high accolades in the field in which what they're doing, just having 20 years of experience is not enough, or just having PhD is not enough. They need to have high accolades and or high achievements in the field of endeavor in which they want to get employed in the US. They are the ones who are eligible for the O1. Like for example, there are movie artists, film actors. They want to come to US to do some performance here, shows or do a shooting over here or anything like that. They can definitely utilize O1 visa depending upon what kind of recognition they have as a movie actors. Like for example, if they have any national awards or state awards or anything like that, those things really play a role for them to get O1 visa. Extraordinary ability visa, that's what it is called. It's something you have achieved highest endeavors in the field of endeavor, in the field in which you are intended to employ it. That those people can use O visa. And other types of visa is P visa, that is performance visa, that meant for usually performance artists or an athletes basically. Okay, if you are an athlete and you want to come to the US, then for example, you have a contract with any US athletic club or anything like that, you should be able to come on a P visa. Same thing with the performance artist. For example, if somebody, a singer or a musician or an actor, they're coming to perform some stage shows temporarily for a few months or anything like that, they can use P visa. Okay, so these are the typical 5 types of visas which people can come into the US and work in the US.
Right. Right. So while I think that was very necessary and informative for all of our viewers, we'll I think move on to the
One more thing I want to tell you, this is not applicable to Indian nationals, but there is one more type visa called E-visa, which is meant for the E1, E2, E3 visa, which are actually investor treaty visas. That means if they are, of course, they do not have a treaty agreement with India, so Indian nationals cannot take advantage of them. But other country nationals can take advantage of E1 or E2 visa with whom the US has a treaty. as an investor non-immigrant visas in this country. If they want to do any business in the US and if they're investing certain amount of money, they can come on that non-immigrant visa and can do their business and everything over here. E3 visa is mainly meant for the Australian nationals, that's like in lieu of H1B visa program. If the H1B visa for Australian nationals, if they don't have any, unfortunately, if they don't get selected in the cap for the H1B, they can actually use the E3 non-immigrant visa to come to the US and work for the employer. The regulation requirements, everything is just like the same as H1B visa, but it's called E3 visa for the Australian nationals.
Right, right. So, like I said, when we're moving on to the set of questions that we have. So while we're on the topic of H1Bs, can a person apply for 2 H1B transfers at the same time? And if yes, how does it work?
It is absolutely okay to apply for 2 transfers of H1B petition. It is up to the employers whether they want to hire somebody in the position, in the specialty occupation requirement which they have. And if as an individual, if you have 2 opportunities and you want to seek whatever is the best opportunity for you is, then you can request both the employers to file an H1B transfer for you, and then you can make a choice with whom you would like to work with. H1B is an employer specific. You can only work for the employer who actually filed your H1B petition. You cannot work for simultaneously to 2 employers unless one of the petition is filed as a concurrent employment petition.
Right. And what steps should an employer take if he or she wants to convert an H1B employee from full-time status to part-time status?
They require to file an amendment to an H1B petition because there's a material change in the position requirements, because from full-time they converted that into part-time position. Therefore, that warrants the employer to file an amendment prior to the commencement of the part-time position to an H1B petition. Filing an amendment to an H1B petition is just like a new filing of an H1B petition, whether it's a transfer or extension or a change of status. It is the same process, same procedures which they have to follow. That means the employer is required to obtain a new LCA, denoting that the position for which they intend to employ is a part-time position, what is the position is, what is the salaries and everything. And once that LCA is certified, then you file Form I-129 and it supplements along with the supporting documents documenting, showing that the position is part-time right now and they would like to utilize the individual services part-time rather than a full-time.
Right. And what happens when a person is on L1 visa and their H1B visa gets approved? I mean, does the USCIS kind of, cancel their L1 status or something?
It all depends upon how the H1B petition has been filed. If the H1B petition has been filed with a change of status request, from the day a change of status request to H1B, and if the USCIS approves the change of status request for the H1B, then L1 automatically gets cancelled from the date the H1B change of status is approved. Okay,
right.
And if that's why it's very important for the L1s to make a note how their H1B was filed with the change of status or seeking a consular notification. If they're seeking a consular notification, then generally L1 status is not expired. They can continue to work on L1 visa until their I-94 expires.
Right. And what happens if a person is on L1 visa, Mr. Bhanu, and can they start their own business, or do they need a green card, to start their own business?
Unfortunately, the L1 individuals cannot start their own business. They can be a sleeping investors or a sleeping partners in any business, but they cannot start their own business. Okay,
right.
Because L1 also has an employment restrictions. They can only work for the company which actually bought them as an intercompany transferee into the US. But L2s, their spouses, can start their own business. They have unlimited freedom to do what they want to do in the US. So L2s can start the business, they can run the business, they can manage the business and everything, but not L1s.
Right. Okay. Understood. So, does an employer need to, continue to pay the required wage, that's already set forth in the LCA?
Yes, employer is required to pay 100% of the wages that have been stated in the LCA and in the Form I-129, whether it's a H1, whether it's an L1, or whether it's an O visa or whether it's a P visa. They have to comply with it. It's very, very important to comply.
Right. And what happens if an employer wants to transfer their H1B to J1? I mean, will they get 6 more years of H1B after the expiration of J1?
No. In order for somebody to subject themselves to a new 6-year period for the H1B, they have to be physically present outside the United States for 1 year. If they don't present physically outside the United States for 1 year, then their cap won't reset. Okay? And that's why they cannot get additional 6 years. If somebody spends 6 years on H1B and then goes on to J1 visa, and after J1 is completed, they can't come back onto H1B unless they have an I-140 approved, or unless they have a labor certification that has been considered pending at least for 365 days. And those are the two requirements which they have to meet under AC-21 Act. And if they don't meet those requirements, then they can't come back onto H1B unless they're physically present outside the country, at least for 1 year, prior to the filing of an H1B petition.
Right. Right, but Mr. Bhanu, what about a situation where a person is probably currently on the 9th year of their extension? Will there be any possibility for that person to probably shift to another company? And if there is, then what is the procedure for that?
They can, provided if somebody is on 9th year of H1B petition, it means they must have already have an approved I-140 for them, and probably their immigrant visa priority dates are not available as per country limitations. Therefore, he was able to seek H1B extensions, and therefore beyond usual 6 years, therefore it was a 9 years. The same thing, he can transfer to another employer provided their I-140 is still valid for that purpose, and their priority dates for the immigrant visas are not available as per country limitations. If that happens, then they can transfer their H1B to a new employer. Or if they qualify for the other provision which I told you before, that if their labor certification or I-140 is considered pending for at least for 365 days, then they can transfer to other employer also. Based upon that, they'll get 1 year extension of H1B based upon that regulation.
Right. Right. So that's great, Mr. Bhanu. We've, I think, finished our questions for today. With that, we come to the end of the session. And like always, we're more than happy to host you. And we feel it's a privilege for us to have our viewers get their opinions and you get their suggestions from somebody as good as you in the business. Thank you so much for being on the show, Mr. Bhanu.
No, it's a pleasure. It's my pleasure, Torni. Thank you. Thank you once again. Thank you, Sakshi TV. Thank you, wonderful viewers of the Sakshi TV. Hope all the viewers are enjoying our show, and hopefully we'll come back and we'll provide more information next week, and hope we'll provide as much information as possible to the Sakshi viewers. Thank you.
That's great. Thank you, sir. You're watching Sakshi TV Live, and this is Torni. Thank you.